Okay. So I hope. Oh wait, hold on. Right. I hope this works and everything. You guys can hear everything or whatever. And right now we are waiting for the court case, and I think for the hearing, the plea deal that's gonna potentially happen with Bryan Kohberger today. And I'm kind of like shocked that it's happening. And I have some thoughts, but I'm going to try not to talk I won't talk during the actual, I'm going to put myself down and then just watch it and try to take notes and then share, what I think afterwards and maybe have a discussion. I was hoping to maybe talk a little bit beforehand, which maybe I still can. Because let's see here. Oh, crap. Maybe not. No, I think I can. So, can I do this? Yeah. Okay. I saw that there was a statement from the Gonzalez talking about, crap, I don't know. Today, here we go. Okay, what? Dang it. Oh, crap. Okay, never mind. So, it's actually on my photos. Wait, maybe I can pull that up here. Anyways, yeah, it is pretty surprising, I think, that they are doing this, and I think I do have some thoughts about like why I think it's kind of bullshit, and like I don't know, like I do feel like the judge has like not really been fair. Like if I was the defense, I would feel super frustrated with the judge right now, and I feel like everyone is just being like really like unfair and actually not seeing the situation really is like it actually is. And it is weird. Like weird stuff has been happening, especially over the last couple of days, and it's made me wonder too. Like maybe that might have something to do with it, with the Idaho shootings. And I kind of did a little bit of sleuthing on that I'll share with you guys too. Like um, another time or whatever. But yeah, it's pretty crazy. Hold on, let me see if I can still see this here. Oops, no, I wanna. Oh God, why am I so bad at this? Okay, no. What the hell is going on? I just need to go to what I took a picture of today, please. Here we go. Okay, so this is what the Gonzalez said, and maybe I'll try to actually present. So let's see if I can do this. Okay. Image. Oh, damn it. Oh my goodness. Well, never mind. Actually, maybe I can do it with a. Maybe not. All right, whatever. I guess I can't really show that right now, which is annoying. But this is what the Gonzalez said. I wish I could just show it to you guys. I've got to be able to do that. Hold on. that I can't share this right now. What would I need to do? I guess maybe I would have to. No. Whatever. Okay, I'm just gonna read. Okay, I'm just gonna read it. I'm sorry, I'm lame. Okay, so the Goncalves, like Kaylee's parents. This is what they said, which is like this is crazy to me. They said this. Right here, right now, we dig our heels into the earth and carve a line deep in the dirt. This ain't justice. No judge presided, no jury weighed the truth. Thompson robbed us of our day in court. Thompson's like the prosecutor, like the guy that looks like Santa. No negotiations, no jury of our peers, not even the pretense of cooperation and fairness. Cowardly men, gutless men, they scatter like roaches when the battle closes in. And Thompson, he's retiring on this deal, his shadow slithering toward the exit, having only the stench of his betrayal. Like, that is pretty hardcore that they said that. Like, wow. They're pissed at Thompson, obviously. No spine, no shred of honor. Um, he didn't have the basic decency, the plain human courage to face the families, to meet our eyes and ask, how do we make an offer that works? And like I feel like what has happened is basically that they have I feel like the state's trying to get rid of it so then they don't actually have to present all this evidence at trial because they know that there's like a bunch of shady evidence and that it maybe would like out people too. Okay, and so then it keeps going. Instead, Thompson cut his deal with the devil. His negotiations didn't require anything other than a simple guilty plea, allowing him the leeway to blame the same people you are paid to protect. You betrayed us, Thompson. Your deal fails to shield the innocent. You could have stood tall and made damn sure the blame stayed where it belongs, not on us, not on the broken survivors still carrying the weight of your repeated failures. This is our courtroom now. This movement, this stand, our voices rise to every American who will listen. We would have provided protection for the roommates, the best friends, the fallen vet, God rest his soul, and every soul and affected in our sheltered community, in our shattered community. And okay, and every soul affected in our shattered community. I think they like misspelled it or whatever. We would have carved our terms like sacred commandments, etched deep into unyielding granite, a testament to those we've lost and the justice that they're owed. Like, this is very intense. First, truth. Sickening detail only the killer could know, the kind that twists your guts just to hear, but turns even a simpleton. Second, okay, first of all, okay, I don't even know. I'm not going to comment yet. Um, Second, you bear the guilt, all of it alone. You don't get to smear the survivors, the ones still waking to nightmares. Third, no cashing in on our grief. No interviews with your ex-professor. No one is allowed to study you. Special. You don't get to spit on our kids' graves by making this all about you. Only mend the wreckage Thompson left in Leta's so-called justice system. This is what murder victims' families' negotiation looks like. It's ugly, it's raw, it's wild, it's anything but easy. I think there's one more. Yet you, Mr. Thompson, didn't even. So this is all we have left. There is no more time for us to wait for you to make a stand. So we stand in your place. Kaylee Jade Gongalves, we love you, baby. You deserved better than this justice system. Your soul is not Thompson's bargaining chip. We do not accept his plea deals signed in your name. We're screaming for you as loud as we can. Kaylee Jade is better than this. This is our last shot. Judge Hippler, you are our only hope that our child murderer isn't granted control over his destiny in our children's names. You take control of this deal and make it right because now you own it. So, like, wow. Okay, and then I think I'll also read. There was a statement from Kohberger's family as well. And let me see if I can find that. what does this one say? Oh, misinformation. Okay, this is what the Kohbergers released today. In light of recent developments, the Kohbergers are asking members of the media for privacy, respect, and responsible judgment during this time. We will continue to allow the legal process to unfold with respect to all parties and will not release any comments or take any questions. We ask that you respect our wishes during a difficult time for all those affected. Um, and then it was like signed from their lawyer. So, and like, so I mean, I don't mind the Kohberger statement. It seems like I feel like his parents and his family are like upset about all of this, and like I think they probably still believe that he hasn't done it. And I bet that they probably understand like why he's actually pleading guilty right now because of like what's on the table, at least in my opinion. And that's what I think is kind of like bullshit with the death penalty is that, like I think a lot of times they can just use it as a bargaining chip. Plus, I'm just against it, period. Like, it's very archaic and you just never know for sure. Like, if that person for sure did it. And I don't know. There's just so many things against the death penalty. And it surprises me that as much of the United States like uses it. But, um, and so yeah, like, I feel like what like Koberger's doing right now is he's just afraid that he's gonna die. Like if he gets like if he isn't really being treated fairly right now. He's not allowed to offer his alibi because he's like the judge said it's not like a real alibi. It's like, dude, but if that's what he was doing, and like also like didn't Ray say that he could like place like Koberger like not at the sign like the scene? Like I just and then he called like Ray like he like super was insulting, kind of like calling it like a fantasy or something. I don't know. He just does not trust the defense at all. You can totally tell like that he just thinks that they're just like playing games and I would be incredibly insulted. Like he did not need to go as far as he did on some of his statements, like in writings that he responded to. And like actually I've been like so yeah, I've been following this case for years and I was planning on doing the live stream of it like coming up now when it was starting. And I'm starting to go through like all of this research that I've done over the past like however many years, 3. And just to start like and presenting some of the really weird stuff that I found with it and that have like really got me just questioning things and like thinking that it might be like definitely there's like a bigger picture to it for sure. Like in no way in hell do not think that, I mean, maybe Koberger was involved, but there's like a way bigger picture going on here too. And I'm starting to see some like themes like across the country and like certain state patrols and like different types of like militias and like military squadrons. And so I just like don't really know how the best way to go about presenting it might be, but I think that I'm just gonna like start from the beginning now because if the trial isn't going on, I think just starting from the top, since like we're not gonna really be able to get the truth from the trial, that just try to do the best that we can, like kind of reviewing the information that we do have and maybe kind of looking at what would have been presented. And like I find so many problems. Like I had made some videos like last summer too with the IgG, and I think that I have like a video out of with an information about just how the new like DNA, just use of DNA in the government right now is like kind of like pretty shady. Like they're not being honest with us about how and what they're using the data for, and they're like trying to trick us by being like, oh, like this is for the benefit, like it's only going to help us solve crimes. But like we cannot trust the United States government with like our DNA. And like it's because that's, I mean, that's like literally the most private thing that someone has. And like we already know in the past like how crappy America has been and just the world has been in terms of like, like weaponizing different, I don't know, like medicalizations of I trust me, I wrote like a ton about it, but um I'm curious as to like why that's taking a little bit longer. It's supposed to start at noon and now it's 12:10. But anyways, so um I really do feel like also like he wasn't allowed to present his evidence of other people that were involved because the like judge was basically saying that they like weren't connected. He's like, you didn't prove that they were connected. And I'm like they haven't really shown like real evidence that wasn't fraudulent or like actually like made up, that would place Kohberger at the crime either. Like, I mean, I'd say that they have the same amount of evidence on Kohberger that they do as like the people that Kohberger was probably asking or like saying that they were involved. And I'm like super interested. Like, I do want to like review some of those documents that got filed recently about those rulings because I was like trying to get this other like huge. I was working on this like the mental health. Like I wanted to go through all the mental health documents, and I actually was like just about to publish like the first video of like a series of like 7 different videos that I was going to do about like how the court was using different. So I have like a clinical psychology background, and I've actually done like assessments that are what they were talking about in trying to present mental health defense and like mitigating evidence with different, mental health evals and declarations and stuff. So, and like also if you get the death penalty and like when you get sentencing, like you are supposed to have like a super comprehensive like review of everything. And it was just like, um, anyways, so I lost my train of thought there, but, um, so I think I'm gonna start with I'll just start. I wrote down like a list of things that I kind of wanted to talk about. Well, let's go back over um, these whatchamacallits, these statements. Okay, the co-workers. So I feel like they probably don't think that he actually did it. And they're just like, along with him, like, hey, you're not really for sure getting a fair trial. And it's better for us to be able to figure all of this out and figure out how we're going to like get you make this right again. And when you sentence someone to death, like once they get put to death, you don't have the opportunity to like prove their innocence anymore, which is like sad. And I actually like did a video before earlier too on like another guy that was on death row, and they were like just coming up with like new DNA evidence that they were trying to present to show that he was like excluded from the crime that he was like being put to death for. And it was like they I'm like definitely getting I'm like, what is going on with the why aren't they starting whatchamacallit? This is lame. But yeah, so anyways, yeah, I think it is important and makes sense. Like if I bet that Anna is gonna try to like present more information. Like that's the other thing that I am really curious about because I like looked up like what a plea bargain like details in Idaho, and they were saying that it can really like vary and differ on each case. Like so each case decides on their own, like with the prosecution and the defense together. So they write up like you can't say this or you have to admit this, and you can't like set any appeals based on the proceedings in this like courtroom or whatever. But to be honest, fuck's sake.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well,
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible, because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following: the defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. but the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself, will be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously, there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Um, And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was the traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest, I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please. No longer the presumption of innocence, and in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume
What
that the
is
trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those
Okay,
that
so
receive their.
I'm accepting that. Let's get started. Okay. So, okay, well, I think I'm gonna just go over a little bit of the things that I like noted. Okay, I don't know what I'm doing, damn it. What just happened? So anyways, yeah, I'll just go over some of the notes that I took on that, and then yeah, for sure stream for the sentencing. And I'm actually like, so okay, what did he say at the end? I think he was like uh order of, I think it's like to like cover it up or like to not release all of the information right now. And he was like, should we open that up now so everyone can read what's going on? I know it sounds like there's like a siren going on behind me because it's like the first Wednesday of the month or whatever. But anyways, so he said that they would get rid of it at sentencing. So I don't like know what that's going to necessarily mean, but I bet hopefully it's going to mean, I mean, that would be crazy if it had like all of the information from that. Like, oh my God, that would be exciting. So, okay, let's just start from the beginning. My notes, just things that I thought stood out. Oh, I thought it was like super interesting at the very beginning when he just like immediately called out like pretty much, you know, the Kaylee's family, the Goncalves, and he was like basically like, I mean, because it sounded like they had a big army like coming at him, and that was like calling the court system, and like the judge was just like not having it, you know what I mean? Like, but he was pissed, and he was like, yeah, I mean, it is kind of funny. Like, I definitely don't like him. I think he's like really cold. And I don't think he's like made a lot of good judgments. But that was a little bit like, I was like, okay, well, at least he's like a total heartless asshole to everyone. It's not like he doesn't discriminate between just being a total douche, uncaring douche. But anyways, and I don't know, I thought what I said, like when yeah, I think he seems annoyed that Bryan took the plea deal. And like he seems really annoyed that they've been spending all this money. Like that is like what I thought really stood out was how much he was talking about money. And like how, I mean, I understand that it's like, you know, a huge thing to like have this much interest in a case and blah 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 blah, but at the same time it's like, okay, you're but like Boise, like you're not that small. And also like none of that is like Bryan's fault. Like Bryan needs to do what Bryan needs to do in order to like figure out his life. Like this was literally like life or death for him, you know what I mean? And like I am just like anyways, so I just that he's a douche like he usually is. But Okay, and then so basically they said also like did anyone else notice that there was like Brett Payne maybe sitting in like the very front row? Like I thought that was weird. And then like it also seemed like when the judge was like saying all their names, he like was kind of like apologizing and then wait. Oh yeah, and then like everyone started looking over to the side and then like there's like a bunch of security guards like moving around and you could tell like all of their bodies like shifted towards that direction where everyone else was looking and it started like immediately after they said like Maddie's name like with the charges. So basically like he outlined like what was going on and he's like so you're going to plead guilty to these 5 charges of homicide and then he's like you have to waive your right. So yeah, there was like a couple things he had to waive his right to. So he said he couldn't appeal like the sentence and I can't remember something else, but I do wonder like what that completely is like entails because feel like I don't know. I'm going to be like really surprised if this is just it. Like I feel like Ann Taylor has to have something like up her sleeve in order to be like I don't know, choosing this option, I guess. So, I mean, I definitely think it was, but it's just weird to hear him say yes to all of that because that was the other thing he had to like, he was like, did you maliciously and preconceived, blah, 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 like, red rum, like, and then he went through like each name and was like a human being and blah, blah, blah. And then like Kohberger was like, yes, yes, yes. Like, it's just weird. Like, I don't know. Like, I really want to get more information about all of this. So, but actually, if all that information comes out though, like after the sentencing, like holy crap, that's gonna be wow. I'm gonna be excited to do that. But I think before then, I'm gonna try to like start over from like where I started looking at stuff because I think even though this plea deal has happened, like I do feel like there's really kind of like a story still to be told about all of this. And I like my personal opinion is that I like still am unsure. I definitely don't like there's weird stuff about all of it and it does feel to me like it was probably more than just Brian and there's like a lot that they're not telling us and so it just confuses me. But anyways, it also said that let's see, yeah. He's like, "This is a little different from the PCA." And then he basically was like, he was like, asked the Thompson. Oh, and it was like super weird. Thompson, like, he was like, he started to like choke up, like when he was like finishing saying like this description of what was going on and like of like during the actual like incident of the red rums. And so, I mean, it was really similar to the PCA, but he didn't really include like as many details. But he was like, yeah, and then we saw this car, and then we saw that, and then he's like, yeah, and then he just started getting choked up, and everyone was, I don't know, it was just so weird. I was like, why are you upset right now? Like, but I mean, dude, like I bet everyone was just like kind of tense. Like, I mean, Hitler was pissed that people were like basically calling his office and threatening, it sounds like. And he was like, I mean, he's kind of just like, how do you guys not know that this is like inappropriate? But at the same time, I'm like, well, I mean, why shouldn't they be able to like share their opinions? You know what I mean? But but yeah, like it is kind of crappy to like also not really involve. Like that's the other thing that it is weird. Like it'd be nice to know why Thompson is feeling like he. I see that. I think it was Thompson. Like I feel like a lot of people were saying that it was like Brian that what I heard through the grapevine of like I don't know, I can't remember where I heard it, but I think it was from like a lawyer that was from Idaho that was like interviewing like on some channel, like news channel, and he said that they wait, damn it. I just forgot what I was talking about. Okay, but anyways, yeah, so then Thompson just tells the whole story, and yeah, he basically like outlined how it was. Also, Hitler, I felt like was like staring Brian down, like when that stuff was being said, which was kind of like weird. But anyways, he said he matched DNA from the sheath. I think some of it was incorrect too. He said he like did a like it was a single source DNA on the like sheath, but then I was like, but I thought it was touch DNA. So like, I mean, single source doesn't necessarily mean anything. Like it's just like, well, yeah, like I guess it wasn't me wonder because I did a bunch of like investigation like into that IgG stuff um and it's really illegal. I was saying that like a little bit right before the um like hearing just took place, but I just think it was yeah. So, okay. Okay, so then the judge agrees and then Kohberger had to say guilty for everything. Oh, and then I thought it was weird. They said that then the judge agreed for everything, and then they said that they were waiving the PSI before sentencing, that the defense wanted to do that, but the PSI is the pre-sentencing investigation, and it's basically like where they take an entire like huge history and like talk to a bunch of different people from um the offenders background, like talking, like looking through their whole like history and then kind of bringing up, what they've been through in their life. And it can include different like mental health and like diagnoses. Like I know that they were trying to use his like mental health diagnoses of like autism spectrum disorder and maybe OCD or something to yeah, to like mitigate some of his sentencing. But now it doesn't really matter because like Hitler was like, yeah, can't change sentencing. And he's like, I can't give them the death penalty like if I'm if it's not agreed to. But I don't know. I thought I read somewhere people were saying that like the judge like does have the opportunity to like decline a plea deal if it wasn't good. So but obviously he was just not having any of that because he was like, nope, I can't do that. So um I thought it was interesting too that he was like saying that there was no evidence found in his car or his office or his apartment. Like he was like, well, of course it was like after 8 weeks after the like red rums took place. So I don't know if that like really counts, but he was like, I don't know. Yeah, it was just um interesting to me that they couldn't find a single shred of evidence. Like, why didn't he mention, like, weren't people saying that Kohberger got found with a, like at his one of the IDs that was like connected to one of the victims, but like that's probably just has been like a lot of misinformation and just false narratives that are being leaked to mainstream media, and like mainstream media just trusts these law enforcement like agencies, and I think it's not always like completely vetted, I mean, so and I definitely think that that's been happening in this case. But um and then he thinks that he got rid of the knife, like he like thinks that he threw it into like some body of water, like there's like two rivers like that come together. But yeah, and so then they said that they could do victim statements at the sentencing. So I think basically what the sentencing is going to look like will just be that yeah, I guess basically they'll just finalize everything, and then they'll be able to do the victim statements, and then I think they the mitigating or like the PSI at that point. Um it is kind of like, what's the point to do that if like there's really no other opportunity, like not opportunities, but options besides, like, you know what I mean? So but definitely the weirdest part of it all was like how Thompson was like crying. And yeah, and then he said that he was like had asked all of the other like trials and court people to not do anything at the courthouse, like on the week of when they were gonna like be starting the voir dire, like so July 23rd or something. And he is like really bothered with administrative stuff. You can tell that he is so annoyed that this thing is like so big, and he's like, I don't want to accommodate for all of this, and but I just kind of have to. But I also feel like, what is he, like the head judge or something? I mean, he seems to like, I don't know. But yeah, and then he also said to drop all of the summons for the jurors that went out. So yeah, I don't know. I think that was pretty interesting. I'm definitely surprised that this is happening and disappointed that we're not going to be able to get an actual trial. And that does feel like there was just like so much that we don't know. So I will help you with that and me with that by starting from the very beginning. And I'm going to start just like doing, maybe I'll just do daily lives, or like maybe do like a daily video, like where I'll start just reviewing all of the research that I started doing and explain my process and kind of show the weird things that I found in this case that make it seem to me that there's something like bigger going on. And even if that's not the case, it's still then a really good story to tell, because it's just like I found like so many themes and like similarities about like different, I don't know, it's interesting. Like yeah, copycat crimes, but also like to movies. Like I found a bunch of similarities with like Alfred Hitchcock like movies, and um yeah, I just have like a bunch of kind of crazy theories. So anyways, I really do want to put that out there, and I'm like annoyed because I just have spent so much time doing a bunch of research on all of these documents that recently got filed in the case. But I think that's fine. Like I think it's still worth going into those. But I think I'm gonna just start fresh now, like after this plea deal got signed, and I don't know, start from a fresh palette, and then I'll just, yeah, I guess start tomorrow with expanding more stuff. But anyways, thank everyone for listening if you're listening to this, and let me know any comments or opinions that any of you guys have about any of these stuff that is going on, and if you think that like, yeah, like if you think he actually did this, or why they'd be doing this for the defense, like it's just confusing. So all right, talk to you guys later. Peace and love. Bye.